I will tell y'all that you saw us laughing as we walked in. It really doesn't make much difference how many years you do this. We still have trouble figuring out who's supposed to walk in what order. So, anyway, it didn't have anything to do with y'all. We were just trying to get in the courtroom. Good morning and welcome to the Court of Appeals. I want to take just a moment and touch on some preliminary matters and introduce the panel before we get started. First of all, I'm sure everyone's experienced here and understands the process, but each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, please request that from the court after you've come to the podium and introduced yourself, but before you begin your argument. You may reserve up to 5 minutes of rebuttal time. The lighting system is on the podium. The lights are green, yellow, and red. So long as the light's green, you've got plenty of time. Once the light turns yellow, you're running out of time. And once the light turns red, you are out of time. We ask that you please respect those time constraints. Very important for everyone to understand. We are live streaming these arguments. What that means is essentially things are going out as you are saying them. So please think about what you're saying and don't say anything you don't want everybody in the entire world to hear, because you have that opportunity to do that. Our panel this morning is Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Anything we need to take up before we get started?
None that I'm aware of, sir.
Okay, well, the way things are going, that's great. So, if you will call the first case, please.
Vondell, Richmond versus City of Clarksville, Tennessee.
Good morning. I would request that we reserve 5 minutes' time. I've never appeared in front of any of the judges here that I can remember, and I will tell you, years ago, one of the first times I came to the Court of Appeals, I was happy to see you come in smiling, because my son had told me that morning, if they're smiling, they probably had a good breakfast, Dad. So I was, that was, I'm glad to see someone come in smiling. My name is...
Any morning that we're able to have breakfast, we're smiling.
Well, that was his point as he went off to daycare that morning. But my name is Mark Olson. I'm an attorney in Clarksville, Tennessee, and I'm here on behalf of Mr. Vondell Richmond. And what we are appealing today is the dismissal of a declaratory action that we brought seeking information. And I'll give your honors just some background. I know you're acquainted with our briefs, but I wanted to give a little bit of background to what's going on. Clarksville has a city council. The city council is comprised of, obviously, members. One of the members was a gentleman by the name of Vondell Richmond. Mr. Richmond was contacted by an ethics committee and some other things going on about whether or not he lived in a proper district. In association with that, he made contact with an attorney with the City of Clarksville's attorney's office. Thereafter, we began to get notice from the district attorney via TBI and other things that he was being investigated. I became involved as his potential criminal attorney, no charges filed yet. And I sent a letter to the attorneys for the district attorney. Ms. Helen Young was at the time the district attorney, and to the lead counsel for the City of Clarksville on October the 12th, 2021. And I referenced the fact that there had been this communication, and we were now receiving information from the district attorney's office that there was something going on. And we also learned that there had been some communication. The district attorney's office made contact with me and said, everything we've got is in some fashion protected, so we're not going to give it to you. Okay. So we turned then to the City of Clarksville and said, hey, we'd like to know if there's been any communication. Don't know if it's good, bad, or indifferent. Don't know that at all. Just want to know if there's been some communication. And we got no response, none. Now, at this point, it's pretty clear, factually, a few things have happened. One, my client had reached out, actually at the suggestion of the mayor of Clarksville, to the city attorney's office and said, you ought to talk to him about this situation that's going on. He did. There was an extensive conversation. Actually, it's recorded. We did not include it in the record because we still consider that to be confidential, and he was being contacted by the TBI. So we thought, just tell us what happened. Tell us if there's been communication. Again, we get crickets. We get nothing. There's no response at all. So I begin looking at it, and I say, okay, I think we're entitled to this. I find this to be not unlike a situation where I have come in as second counsel, or someone has come in for me and said, I would like to, number one, get your file. I would like to talk to you about what's been going on. I'd like to know what kind of communication there's been. Nothing, nothing. So we began looking at it in my office and said, what are our professional duties here? And that's where I begin the analysis. And we begin by looking at Rule 1.4, the Tennessee Professional Responsibility Rules, that said, you have a duty to communicate with your client. And if your client asks you for information, you have a duty to communicate that. Now,
I guess the question is he a client?
oh yeah, absolutely, extensive.
In what capacity was he a client of a city attorney?
Number one, he thought he was, and number two, there was extensive advice given. Absolutely, absolutely. As a matter of fact, the city has referenced in previous litigation, other litigation, that the city attorney's office represents and is there to provide counsel to the city council members. Absolutely.
Is that a disputed issue in this case?
To my knowledge, no. I mean, to me, that's as though someone comes to me in my office and says, oh, here are the facts. Here are the facts of this situation. What is your thought process? And then the response is, well, you need to look at A, B, C, D, E. These are the things that you have to do. I'm sorry, at that point, confidentiality has arisen.
You don't see a distinction between someone coming into your office and someone speaking to the city attorney?
Absolutely not. Absolutely not. Absolutely not.
And what case law do you have that supports that position, that a city council person who talks to the city attorney is doing that in some confidential relationship? The city attorney doesn't represent each and every council member.
Certainly does. City attorney's office represents the council members anytime they're involved in litigation. It represents them with regards to matters brought against them. Absolutely, positively. And this is the other thing. If they don't, then you don't need to act, you don't need to be referred to the city attorney's office for advice. If that is in fact going to be the position of the city of Clarksville, we do not have a duty. I was an attorney, yeah, I was an attorney, but I don't have a duty to you after I've talked to you and given you advice, then that is a way different standard than that, I think, that is presented by the Tennessee Board of Professional Responsibility Rules. If the client believes reasonably that the attorney-client privilege has attached, then the attorney-client privilege has attached.
You think that's the standard?
I do.
Was he speaking to him in his capacity as
sorry,
a
sir, I
city
can't.
Was he speaking to him in his capacity as a city councilman about city council business?
No, it had to do with matters as to residency and that type of thing. It had to do with whether or not you are a resident of the district in which you are voting from. That's what it had to do. And then there's specific discussion regarding the factual basis. That very specific, not factual basis as much as these are the factors you have to take into account. So yes, absolutely. Unfortunately, and this is 38 years, 40 years ago now, my understanding of the rules is you can have the attorney-client privilege attached inadvertently. You can talk to someone and the discussion goes too far. Frequently, I have that happen in my practice. I think I do a good job in one type of case, and I will have people come in and try and talk to me about their cases because they don't want us to be involved.
Well, I don't have any problem there. I think the concern is in your capacity, you're in the capacity of a private attorney.
I am,
This attorney, he happens to be the city attorney,
correct.
but he's the city's attorney. And the question is would that same attorney-client privilege attach to someone who's not the city?
Yes. He is the city. He is the city council member. He was instructed, as the complaint says, contact the city attorney to discuss this matter.
So it was about, I guess what I'm trying to understand is, was it about city business?
Yes, it is. It's whether or not you're in the proper voting ward is city business. Absolutely. That's exactly what it
Well,
is.
maybe then he might be. I don't know. But
Well,
I'm just saying, I
yeah.
mean, if he came to talk to him about, some criminal case, and not like he would come talk to you.
And that, I want to say, and I've read, obviously, council's brief, that is a canard that is not going to fly. And this is the reason why. You're the attorney. You're consulted for a specific reason. You give advice regarding a specific reason. Later on, you don't get to come back in and say, oh, but, I really wasn't providing you advice. You shouldn't rely upon the fact that I was giving you advice. And the reason that's a canard is this. My client has still expressed to the city attorney things that are confidential, and but for the belief that there was that relationship would not have been discussed. Period, end of story. That's when the attorney-client privilege attaches. It's not, I'm about out of time here, but that's when, in my estimation, the matter became important. And respectfully, there's not a whole lot of case law on this. We looked, there's significant discussion in the professional rules. There's discussion about this kind of thing in the federal model rules. But this is a situation where if you're getting the advice, then that's it. And this is one point, I know I've got 30 seconds left. This doesn't have anything to do with, oh, are you the client or not? The client becomes the client when, in fact, you're giving confidential information. The question then becomes, under Rule 1.4, do you have a duty to tell us what you told others? Do you have a duty to tell us if there was anything? And again, there were three ways we could have done this. Could have said, I had a conversation with this person about this. I've had no conversation, or I'm not going to tell you because it's privileged. We didn't get any of that. We got none of it. None of it. And I'm out of time. I'll be back.
Well, let me ask you one question.
Yes, sir. Yes, sir.
You said he was instructed to talk to the city attorney.
Yes.
Who instructed him to talk to the city attorney?
The mayor of City Clarksville.
Okay.
Is the mayor a lawyer?
I'm sorry, sir. I'm a little
Is
deaf.
the mayor of the city a lawyer?
The current mayor is not. And I understand that you're asking that more broadly, but
Why should he rely on what the mayor is saying about who he should talk to? Why did he not seek you out to begin with if he thinks there are criminal charges coming?
well, there weren't at that time. There weren't at the time. That's really where the foundation of this thing comes in. The question is, are you in the proper voting ward? So the mayor said, you ought to talk to the city attorney about whether or not you are in the proper voting ward. So there's this lengthy conversation that he has, and then thereafter, there's discussion with TBI agents and people coming around wanting to look at prosecuting him. And we know that there's been another person who's been prosecuted who is on the city council. So, and actually entered a plea is my understanding. I'm not followed up on that. But from my perspective, it's important for me to know what was discussed by an attorney with whom my client had a discussion after that discussion occurred. No different than someone coming to me in a situation and saying, hey, by the way, I think this, and this, and then later something comes up. I still have two duties. I have a duty of confidentiality, and under Rule 1.4, I have a duty to reveal what I said.
Okay.
If-
Yeah, I think you've answered Judge Armstrong's question. You've got your rebuttal time.
Thank you, sir.
Thank you. We'll hear from the appellee.
Good morning.
Morning.
Jeff Goodson for the appellee, the city of Clarksville. I'm of the Montgomery County Bar. Out of the gate, I'll address the issue, Judge Golden, that you raised and that we've discussed extensively here. Who's the client? Now, of course, that doesn't address whether the trial court had subject matter jurisdiction over this quote-unquote declaratory judgment action, but I do want to address it. It's a good question. As the former president of the Tennessee Municipal Attorneys Association, I can tell you a city attorney such as Mr. Baker always, in every circumstance, has one client, and that is the municipality, the city. And it says so in the city's charter, which, of course, is basically the constitution of the city of Clarksville. And if there were a conversation that strayed into matters such as a criminal investigation against an individual and potential criminal charges, that's not the nature of Mr. Baker's representation of the city, and certainly wouldn't extend to any individual council member. And I noticed that what did Mr. Richmond do? He went out when there was a criminal investigation or concern over criminal charges, and he didn't get Mr. Baker and retain him, did he? He retained Mr. Olson. So the city attorney has one client, the city. That's the way that it always is. Now, as to really the matter at hand, did the trial court do the right thing in dismissing this matter and granting the city's Rule 12 motion for lack of subject matter jurisdiction and for failure to state a claim? And the answer is a resounding and respectful yes, for a number of reasons, and this court should uphold that decision. First,
let me ask you a question here. What is it that you understand the relief the appellant's requesting here?
considering that the appellant recorded the conversation, which is an interesting act to do if someone thinks they're getting advice from a lawyer they trust, I think that it looks to me like it's an improper use of the Declaratory Judgments Act as a stepping stone, says the case law, to another proceeding, perhaps a Board of Professional Responsibility complaint, or perhaps, as the case law frowns upon, using the declaratory judgment action to get the relief of assistance in another matter, such as a criminal proceeding. So I believe that's really what's going on, and they were hopeful, Judge Stafford, of maybe some sort of a ruling from the trial court that Mr. Baker had violated a rule of professional conduct.
What is the purpose that is attempting to be achieved here?
That's probably a question best aimed respectfully at the plaintiff, but as best I can speculate.
Well, I'm just asking from your perspective, because I will ask that question, or just consider it asked.
Yes, Judge, thank you. I think, again, it was to serve as a stepping stone to either a Board of Professional Responsibility complaint against Mr. Baker, depending on what the DEC action would have revealed. And I think, as Mr. Olson said, and as the complaint says, it was a declaratory judgment action that in an unorthodox and really improper fashion just sought to obtain documents. So perhaps the purpose was to obtain documents to get a leg up, maybe, or to allay the plaintiff's fears of what might be coming on down the line in the criminal matter.
Well, is there a distinction here? And I may be going far afield, and if I am, tell me. But is there a distinction here, because you said this conversation was recorded?
That's been pled, yes, sir, Judge.
Is there a distinction between the conversation that was had as opposed to the conversation that the attorney, the city attorney, may have had with other authorities? Is there some line, artificial distinction here?
None that I can think of.
Okay.
Standing here. Of course, this notion, and this is important for the Declaratory Judgment Act prong of this, which is the only prong. That's what this was, and it was dismissed. This notion that the city attorney communicated with the DA is just a hypothetical. It's an unknown fact, and it was pled that way. And it's important to note that when the trial judge granted this motion and dismissed the case for, among other reasons, lack of a justiciable controversy. The trial judge, in so doing, was taking the plaintiff at his word based on the allegations in the complaint. The trial judge assessed the complaint, and here's what she assessed. For example, the complaint referenced, quote, records and communication that the plaintiff sought to obtain via his declaratory judgment action. Then the plaintiff turned right around, and this is at page 1 of the record. Then the plaintiff turned right around and described those records and communications in a hypothetical sense, saying, well, I want them, quote, to the extent they exist, end quote. Another example in the complaint, and the trial judge considered these allegations, the plaintiff alleged that he believes, used that word a lot, he believes or suspects there's been communication between the city attorney's office and the DA's office about this issue of residency, and that he wanted a full disclosure of the transfer of information, he said in the complaint, but then he turned around again and couched it in a hypothetical sense and said that he, quote, has been unable to determine whether any such transmission of information actually occurred. Now on appeal, this theme of the hypothetical and the unknown continues. It continues. I noticed that in the brief, this is at page 9 of the appellant's brief, he says he filed this lawsuit because he, quote, desired to know what information was being transmitted from the city attorney's office. In other words, he does not know, but he wanted the circuit court to entertain the hypothetical notion that communication happened. Not surprisingly, and the trial judge picked up on this, he entitled his complaint as one to, quote, compel the providing of information. Well, what sort of information? Hypothetical information that is unknown. Lastly, as far as the brief is concerned, I noticed that the appellant said he filed the lawsuit to determine if privileged information had inadvertently been released by the city attorney. Again, he doesn't know, has no idea, but wanted the circuit court to kind of help him out, allay his fears, and find out. And perhaps I can size it up chronologically like this in just 4 simple steps. There's a one-time conversation that occurs between the appellant and the city attorney. It gets recorded by the appellant. Number 2, shortly thereafter, he's investigated, or he learns that he's being investigated for criminal charges. Number 3, he assumes, but he does not know, that the city attorney is the one that instigated the criminal investigation. And then number 4, finally, he files the declaratory judgment action to try to have the trial court help him find out whether such a thing happened. And as this court well knows, there is a steady and consistent body of case law in the state of Tennessee holding that the Declaratory Judgments Act does not empower trial courts to issue advisory opinions on a state of hypothetical facts or to make declaratory judgments based on unrealized or future scenarios. And this is all the more important as well. Tennessee decisions hold, and I've already referenced this, we can find this in National Bank, Third National Bank versus Carver, 218 Southwest 2D 66, Tennessee Court of Appeals from 1949. It's often cited. But a plaintiff can't use the Declaratory Judgments Act to assist him in another transaction. I referenced that. Like, say, a future criminal case against him. He can't use the Declaratory Judgments action as a stepping stone, as I mentioned, like, say, a stepping stone to a Board of Professional Responsibility complaint. And significantly, and I believe the trial judge rightly so, she commented on, relied on, cited Parks versus Alexander, 608 Southwest 2D 881, that's a 1980 Tennessee Court of Appeals decision, that holds you cannot use the Declaratory Judgments Act to allay your fears as to what might happen in the future. So in sum, the trial court rightly dismissed the matter for lack of a justiciable controversy, and this court should affirm that particular ruling. And I want to turn, though, briefly, as I start to wrap it up, to what is the plaintiff's sole argument on appeal, the appellant's sole argument on appeal, and that is, well, there's this duty to provide information that the city attorney allegedly violated under the rules of professional conduct. So let's entertain that notion for a moment. It's well settled in Tennessee. In our brief, we cite a number of different cases on this going back many, many years, that the rules of professional conduct cannot provide a basis for a civil claim. Those are disciplinary rules for attorneys. And the case law says it in a rather sweeping fashion. It doesn't say you can't use the rules of professional conduct or a violation of same as a civil action or as the basis for a civil action against the lawyer. It says as the basis for a civil action, period. Period. Whether it's the Lazy 7 coal sales case that we cite too extensively from the Tennessee Supreme Court in 1991 or other cases. And perhaps the courts in Tennessee expected and predicted that this type of thing would happen, that a plaintiff would try to use a supposed alleged purported violation of the rules of professional conduct as the basis of some civil action against anyone. It's improper. The Montgomery County Circuit Court, of course, does not have subject matter jurisdiction over what in effect are board complaints. We know the Board of Professional Responsibility is the sole specific disciplinary agency having subject matter jurisdiction over such things. So the Montgomery County Circuit Court, if we take the appellant at his word that he's just trying to investigate whether the city attorney violated the rules of professional conduct, that court did not have subject matter jurisdiction and never would over this type of complaint. That leads me to another interesting point. The city attorney is not even a party to the action, never has been in any capacity. And if in fact it were proper for a declaratory judgment action to be brought against the city attorney, and it's not for reasons we've already discussed, but the Tennessee Code at 2914-107A, section 2914-107A, says that you've got to bring everybody into the declaratory judgment action who's got an interest in the outcome or is affected in the outcome of the declaration that's sought. Certainly the city attorney would be such a person who would have an interest in a declaration saying that he's violated supposedly the rules of professional conduct. But the plaintiff didn't add him as a party. Instead, the plaintiff sued the city of Clarksville for, in effect, a purported violation of the rules of professional conduct. And I realize this is so simple, and so please pardon me, it's so elementary and foundational, but obviously the city of Clarksville or any Tennessee municipality is not subject to and cannot violate the rules of professional conduct. I never saw a Tennessee municipality sitting next to me at the bar exam. The lawyers get licensed. The lawyers are subject to the rules, and that's who's disciplined. So to say it another way, the plaintiff didn't add the city attorney to the suit, and he lacked standing to sue the party that he did name, the city. He doesn't have standing to pursue the city of Clarksville for a supposed violation of the rules of professional conduct. And finally, as I wrap this up, there's a presumption of which I know this honorable court is well aware, long-standing presumption in Tennessee, that public officials and quasi-public officials, to include in-house governmental attorneys, there's a presumption that they have followed the law, that they know the law, and that they've discharged their duties in good faith. And there was nothing pled in this complaint to suggest that that presumption should be undone, to suggest that it should be overlooked. And in fact, this lawsuit flies in the face of that long-standing, well-recognized presumption. So those are just a few of the reasons why this duty to provide information argument is meritless. The last thing that I'll say, as far as the standard of review is concerned, the Tennessee Supreme Court has observed that an action or a decision by a trial court to refuse declaratory relief is one that should not be disturbed on appeal unless it is arbitrary. That's the standard. Certainly, the circuit court's decision here was anything but arbitrary, was well supported. There's a lack of subject matter jurisdiction. It's a failure to state a claim all day long, and respectfully, we would request, the city would request that this court uphold the dismissal. Thank you.
Thank you.
Rarely have I had an argument that I think buttressed my position more than the argument that just took place. Because what you just heard was everything except three things. There was no communication, there was communication and this was it, or it's privileged. What we have is a municipal attorney, the city attorney, who specifically gave advice to a city council member saying that you can't know what I said about the advice I gave you after this. You can't know if I said anything. Interestingly, and this has got to be something, if I'm a city council member in the city of Clarksville, I'm going to sit down and I'm going to look at this and I'm going to listen to this argument and I'm going to think to myself, who am I talking to and in what capacity when I talk to the city attorney? Because if the general rules of when the attorney-client privilege attaches do not apply, then that needs to be outlined. Because we get back to this again. We can talk about standing, we can talk about declaratory judgment, the standard before this court. But what we haven't talked about is the one thing. Did you communicate? What was the communication? Or are you claiming it's privileged? That's the issue. And respectfully, the Tennessee appellate court decisions state the Board of Professional Responsibility rules are guidance to this court. In other words, those rules demonstrate what is appropriate and what is not appropriate. And Rule 1.4 says clearly, you have a duty to communicate with your client after there's a discussion. That's like me not communicating with a client. That's like any attorney not communicating with a client. That's like me refusing to give my file to the new attorney. Now, there was one question
Let me ask
that
you, why do you say standing is not an issue? And whether or not you have the proper parties, whether you had the proper parties, even before the circuit court?
Because we believe that there was more communication than just the city attorney. There's an ethics board also. So there could be more communication. And again, I go back to the three things that I identified. There was no communication, this was the communication, or it was privileged. Those are the three things that I think were reasonable responses and required under Rule 1.4 of the Tennessee Professional Responsibility Rules. You know, if I have something that's known in my office, my whole office is held to that standard. It's not just Mark the lawyer. It's Mark the lawyer governing his staff and making sure that we comply with the rules. And I'll say this too. We keep talking about the Board of Professional Responsibility. I've done this for 38 years and I've never had to file a board complaint against another lawyer. Just haven't had to do it. Because no one does this kind of thing. No one says, you don't get to know what the communication was. And I don't want to do this to this gentleman. That's not what I want. I choose to think he's made a mistake in not giving us the information. And I think it is a mistake to tell us, not tell us, yes, I did this, no, I did not do this. And I've only got a minute and a half left. Your Honor asked the pertinent question, what is it that we want? Tell us. All we're looking for is what was said. And if it's nothing, we're going to have egg on our face. Gosh, that's it. But that goes against the grain of what we learned from the district attorneys. We consider all the communication to be privileged. Okay, got it. I understand that. But it's not privileged from the city attorney. It's not. He does not gain some privilege through use of the district attorney's office. He still has the requirements that are imposed on any attorney in the state of Tennessee. And again, I'm almost out of time, but you know, there were a number of things that were discussed, but the main thing that comes down to is this. Is there a duty after I am consulted, any attorney is consulted, and my client is assured that I am the lawyer. And again, I understand that there may be some question on that, but I don't think that there is. When I am called and I am consulted, I am the lawyer. I am required to maintain conflicts lists. I am required to not reveal confidences. Frequently, people come in and tell me things that they don't want everybody in the world to know, and I'm not supposed to reveal it. I don't get to then turn and say, oh, by the way, I'm going to represent this person who you told me about. And that's what this is about. And thank you very much.
Thank you. Council, thank you for your argument. Thank you for your briefs. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. You may be excused. Thank you. You may call the next case, please.